In this module, we are going to talk about data breaches, and the legal implications from a litigation perspective. Now, as we saw in the previous module, the kind of penalties, the kind of monetary penalties are the highest that our country would have seen if the legal implications, the implementation and the litigation in this particular legislation further ensues. Now, the first thing that you need to understand is that under this particular bill, which is en route to become an act now, the bifurcation of personal data as sensitive personal data and only personal data is not there. Now, this is something which the sensitive personal data protection rules had earlier on created, this bifurcation of data. Now, honestly, that made it very difficult even for organizations to bifurcate or even for implementation authorities to segregate such data in the data mapping process, which is a part of the framework to be implemented. Now, you need to understand one thing. Here, there is only a concept of personal data, which per se is going to mean data which enables identification of an individual, HUF, organization, firm, incorporated or not, society, etc., etc. And also, it would also include identification indirectly. So data which is not just directly identifying them, but also indirectly in any way leading to the identification of individual, a person, or you could say an organization, HUF, firm, etc. So this is basically the aspect of data. Now, let's just see the definition of personal data breach. It is talking about loss to data, destruction to data, unauthorized access of data, and one of the most important words that you need to understand, accidental data breach, data loss, data destruction. Now, the word accidental has extreme implication out here that you need to understand, because here, as in criminal law, what we talk about is mens rea, where intent, guilty mind has to be proved. Here, you need to understand the concept of guilty mind does not exist. So accidentally, you may not have adequate security and your data is lost, or there may be a situation in your organization where an employee is stealing your data. Then also it will be the burden of proof is on you to prove that you did not have the intent, and even then the intent being there or not being there is not really going to be something that is going to be considered in the process of determining a penalty. So one thing that you need to have a clear understanding of, like in the first module, I had mentioned about it covering physical and digital data. And there was this query that came up with a large number of people that said that, okay, the bill talks of digital personal data protection. Then where does the question of physical data come? Now, if you just go about reading section 3, it talks about the provision of this act applying to digital form of data and non-digital form of data, which may be collected physically and subsequently digitized. So you need to understand data protection consists of two aspects. First is collection, thereafter is the processing. So if the collection is physical and thereafter it is processed digitally, it will come within the ambit of this particular legislation. Now, what are the exceptions to this? The exceptions are going to be that if the data is for individual domestic purpose, persons, their own data which is they are processing, or the data is made publicly available by the data principal himself, or under any other person who under the law has an obligation to do the same. Now, when I mentioned that even physical data by default will come in the ambit, now from an interpretation perspective, how would this happen? So let's say as an organization, you are only collecting physical data, you're processing it only in files, physically, manually. However, if an employee goes ahead and creates a scan of the document or takes a picture, so a rogue employee does that, leaks the same document, let's say over the internet, surface web, dark web, etc., the onus of proof that you are not processing it digitally is going to still come upon you. We are not talking of a guilty mind here. So when you are going to be summoned up by the Data Protection Board, the onus of proof is going to lie upon you, which is going to simply end up meaning that you need to have adequate physical security for physical processing of data and digital security for your digital data. So by default, as a data controller, as a data processor, you are going to end up having the liability and the responsibility also for the physical data processing, so that it doesn't end up leaking on the internet. Because you need to understand, as a matter of proving, you will have to end up proving as to how this data has landed up on the internet in a digital format. So this is something that from a litigation perspective, because obviously this entire proceeding, the entire legislation is going to have a large amount of litigation, and that too of you could say considerable value and also of great importance because of the nature of penalties and the value of penalties. So exercising caution right at the beginning is something which is very, very important to ensure that you don't end up in a situation wherein the burden of proof is upon you as an organization or individual and you are unable to prove the same. These things are very technical and very difficult to prove. Now let's come to the concept of data processing. Now processing obviously means any form of activity that you're performing on the data, whether it may be data segregation, data storage, any form of analytics that is being performed on the data, transmission of data, a lot of other activities which once you collect data that you are performing on it, whether by physical means, automated means, is included within the definition of data processing. Now, in this particular module, we have understood what data is. Under section 3, what data needs to be protected, what is the, you could say, exemptions under this particular act to applicability, what kind of data is coming within its ambit. Along with that, we also saw what a personal data protection, what a personal data breach means, and the implications of mens rea, guilty mind not applying in this particular case. How physical data protection is also something which an organization will have to very clearly think about, especially if you're physically collecting and processing data. Because end of the day, everything is digitized, so it may not be digitized at your end, but at a breach end, it can get digitized, and the onus of proof will lie upon you. And the onus of proof, even claiming that you don't fall within the ambit of this act, is going to be left to you to prove before the board. And the concept of data processing, the meaning of data processing again primarily referring to digital data is what we are talking about here. With this, the next module that is going to be on consent and legitimate usage of data. And along with that, we will try to squeeze in even the breach notification aspect.